Hello everyone, welcome to Legal Darshan. In today's video, we are going to discuss the case of Dr. Ashwani Kumar versus Union of India and another. Dr. Ashwani Kumar comes out as a PIL activist, and he has filed number of PILs in the Supreme Court of India, invoking the social causes for the countrymen. Okay, now this judgment is numbered at 54 in the list of AOR leading cases, and this is one such judgment where this PIL activist, Dr. Ashwani Kumar, he is filing a writ petition under Article 32 for the purpose of seeking effective and purposive legislative framework based upon Convention Against Torture and Other Cruel, Inhumane, or Degrading Treatment or Punishment adopted by the United Nations General Assembly. Okay, now the court is the petition is basically highlighting custodial torture. Okay, now custodial torture is one of the causes that have been in discussion so far. So we have had discussions on DK Basu, we have had discussions on Sunil Batra versus Delhi administration. Many such cases do look out for custodial torture, and there are several guidelines that have been issued with respect to custodial torture. There have been advisories, rule books being issued against custodial torture, but once it is, in my opinion, we are failing at one thing, that we are not able to bring in any law, any legislative framework, any legal code, or any act against custodial torture so far. Okay, now there is no specific we do take we do take indirect application of law in consideration, but there is lack of direct provisions that penalizes custodial torture so far in India. Now, pursuant to the same cause, this PIL activist, he is also seeking effective legislative frameworks based on CAT, which is Convention Against Torture, adopted by UN, and it is the prayer of the applicant of the PIL activist here in that the court should invoke its exercise under Article 141, 142 for the protection of advancement of human dignity, which is a core of constitutional right. Because if, I am a prisoner, I am being tried, I am an under trial prisoner, or even if I am a convict, the law should be one punishing me, the court should be one punishing me. The custodial torture goes outside the domain of, justice, because it is I am, if I am a prisoner, let's say if I am a convict, I am undergoing my punishment. Okay, it does not give any because just because I'm a convict, the officers therein, or even the prisoners, inmates therein, do not have a right to torture me unnecessarily. We have looked at the data. There are numbers of deaths that happens in custodial deaths. Okay, there are number of sexual harassment cases that happens with women imprisoners, right? So why are we not making any laws against it? So the petitioner herein is also seeking advisory being issued in the exercise of Article 142 of the Constitution of India by the Supreme Court, so that there is some effective remedy for them. Now, time and again, the Supreme Court has intervened. When it was Vishakha, Supreme Court has intervened and formulated guidelines against the POSH, prevention of sexual harassment at workplace also, right? And when the Supreme Court invoked its 142 jurisdiction, when we read about, this. Curative petition in Rupa Hora versus Ashok Hora. So far, court has taken interpretations. Okay, Article 21 is in a direct question here. When we not make any laws, we are indirectly allowing custodial torture to continue. Even though we do have advisories, we do have rule books, but there is no solid law that provides punishment for such an act. Isn't it that we are also, in a way contributing to the process of custodial torture by not making any law? So for that question, we invoke Article 21, that it is violative of my Article 21. It is also violative of my Article 14 as well, when I am being subject to custodial torture time and again. Right? So basically, this case was about custodial torture, but the judgment, when it comes in this case, it is made about separation of powers, because the courts herein are exercising judicial restraint. Courts do have Supreme Court have had made laws regarding it, but now in this regarding the issues that came before it, invoking 142 jurisdiction, like we were just discussing, curative petition in Rupa Hora, Ashok Hora, the Posh Act case, Vishakha's case, Medha Kotwal, Lele's case, the court has issued some advisory, some directives, right? Even in DK Basu, there were some directives issues. We have read those 11 guidelines that were issued in DK Basu. Arnesh Kumar also is one such case where court has been actively, issuing guidelines. But in this case, the court is exercising judicial restraint. The court herein is saying that in exercise of Article 142, where there are some extraordinarily lying cases, we do invoke the power of 142 here. 142, if judicial activism is there when there is a need, but just because there are some mere allegations of violation of human rights or a plea arising out of environmental concerns, it cannot be a bright line to hold that self restraint must give way to judicial legislation. Okay, so where and whenever we are full full fully on the fact, fully supportive on the fact that directions must be given by invoking Article 32 or 142 jurisdiction of the Supreme Court, we do issue the directions. But however, when it is unwarranted, that strikes constitutional debates, constitutional dilemmas also, and such directions are to be issued also with great care. Now court herein is saying that, but however, this is a case where there is mere allegation of violation of human dignity, rights of custodians in prison, of people being in custody in prisons. We do not find it a very fit case that requires court's intervention for framing of the law. Basically, the petitioner is seeking directions to executive by way of this case, and court is refraining itself from doing so, and also refraining itself from releasing any guidelines under exercise of Article 142 of the Constitution of India. Okay, now the court herein is saying, when the matter is already pending consideration and it is being examined for the purpose of legislation, it would not be appropriate for this court to enforce its opinion, be it in the form of a direction or even a request, for it would clearly undermine and conflict with the roles assigned to the judiciary under the Indian Constitution. No directions can be given to the executive to ratify the UN Convention, for it would virtually amount to issuing directions to enact law in conformity with the UN Convention. Constitution of India, Articles 21, 32, 141, 142 used herein. Okay, so the court, basically the petition being filed for ratification of United Nation Convention Against Torture, is a direction that the court is issuing, and it would amount to an issuance of direction to enact the laws, which is not permissible by the Indian constitutional scheme. That is what the court is holding out. Now the court in this case builds on the separation of powers doctrine. Okay, so the court is discussing what separation of power doctrine stands in India, right? So there is a wider discussion on doctrine of separation of powers in this case. If you look at, court is saying, okay, so court herein is basically dividing the role of legislative, judiciary, and executive in India. Court, it is also mentioning some articles. Okay, so in the very first year of our law schools, we are made well versed with the doctrine of separation of powers. It is an important element of jurisprudence. It's also an important element when we study constitutional law as well as administrative law. So we do know that in separation of power, the Indian structure is not as rigid as that in United States. Okay, so we do have overlapping jurisdictions of legislature, judiciary, and executive as well. So executive do exercise pardoning power, the power to pardon somebody's punishment, and that exercise it does in the judicial function. Also, executive sometimes when it makes ordinance, it is also sometimes using its legislative powers as well. Similar goes with judiciary. When judiciary uses the rule making jurisdiction, 145 jurisdiction of the article 145 jurisdiction of the Constitution, or it sometimes issues guidelines under exercise of Article 142, that may fall when the judiciary is discharging legislative function. And when the legislative assembly speakers, they are uptaking a case, speakers are deciding whether a person is guilty of corruption, or whether a person should be the judicial the review that the speakers conduct in cases of defection, that is where legislature is also discharging some kind of judicial function. So there is significant overlapping within these three functions, but that doesn't mean that the one field should encroach on the field of another. So the court herein is also invoking some articles, for example 72, 161, 123, 123, 213, so that it is expounding on the concept of separation of powers, which we all have studied someday. Article 73, Article 162, that how state makes laws, whether executive has power to make laws. In the case of Ramjavaya Kapoor, it has been invoked earlier, right? So these are some discussion on separation of power that the court herein is taking, and holding that it restrains the legislature from declaring the judgment of the court to be void. And also, while the legislature still possess the legislative competence of enacting a validating law for which remedies the defects pointed out in judgment, it does not ordain and permit the legislature to declare a judgment as invalid by enacting a law as well. Okay, so similarly, uh, you know, while the court cannot write a legislating act, the legislature also cannot demean a court's judgment, but rather takes an essence out of it and modifies laws to that extent. So court is basically pointing out the checks and balances that are needed to be kept in exercise of doctrine of separation of power. And in this case, the court is denying to issue any directive to the executive or to the Union of India for ratification of the United Nations Convention Against Torture, and in exercise of Article 21 of the people who are held in the custody and are suffering custodial torture, right? So basically, moreover, this case had become more about doctrine of separation of powers rather than the ratification of the Convention Against Torture, which is the demand of the petitioner in this case. So separation of powers, if one wants to study separation of powers, even the head notes that are given in this PDF that is uploaded on the website of AOR examination, it is a very sufficient material here in which one can rely upon to study doctrine of separation of powers, right? So this is it for the video on the case of Ashwani Kumar versus Union of India. And I hope the discussion is useful for you. For more such videos, please stay tuned with us on Legal Darshan. Have a great day.